Chapter 4, Legal Liability of CPAs. In the current era of litigation, investors and creditors who suffer financial losses and experience market downturns are likely to find CPAs, as well as attorney and corporate directors, tempting targets for recovery through lawsuits that allege professional malpractice. Unlike physicians and attorneys, where the injured party is limited to the patient or client, CPAs who are negligent in expressing an opinion on financial statements may have millions of investors as well as firm creditors that may sustain losses. Amounts in excess of $300 million have been awarded to parties as a result of litigation against public accounting firms. Sometimes these losses will exceed the accounting firm's professional liability insurance. In such cases, the awards may require further payments by the firm itself, personnel who worked on the engagement, and certain other partners. In some cases of litigation, the CPA's liability may be relatively obvious. In others, it may not be obvious whether the situation was due to inadequate performance or other factors. Financial statements involve the use of many estimates, such as the allowance for estimated warranty costs. If an accrued liability for estimated warranty costs proves to be seriously understated and the actual cost incurred cause investors to sustain large losses, the investors may attempt to recover from the CPAs, whether they are at fault or not. If the cost of bringing a suit against a company's CPAs is relatively low and offers even a chance of recovery, the injured parties may initiate legal action. In the United States, CPAs have both common law and statutory law liability. Common law liability develops through case decisions generally arising due to breach of contract, negligence, and fraud. Statutory liability develops when governmental units pass laws and regulations that impose liability on CPAs. CPAs enter into a contract with their client, ordinarily through an engagement letter, and agree to provide services. The potential for liability occurs when there is a breach of contract and when damages result due to a failure of one or both parties to a contract to perform in accordance with the contract's provisions. In the case of a CPA firm, a suit might be brought by the client for breach of contract if the firm fails to perform the engagement in accordance with the engagement letter and the client suffers damages as a result. Both clients and third parties may sue CPAs for the tort of negligence. A tort is a wrongful act, injury, or damage not involving breach of contract for which a civil action can be brought. Negligence, referred to as either ordinary or simple negligence, is a violation of a legal duty to exercise a degree of care that an ordinary prudent person would exercise under similar circumstances. Gross negligence is the lack of even slight care, indicative of a reckless disregard for one's professional responsibilities. Fraud is defined as misrepresentation by a person of a material fact known by that person to be untrue or made with reckless indifference as to whether the fact is true, with the intention of deceiving the other party, and with the result that the other party is injured. Constructive fraud differs from fraud in that constructive fraud does not involve knowledge of misrepresentation within the financial statements. CPAs have statutory liability under both the federal securities laws and state securities laws, often called blue sky laws. The Securities Act of 1933 and the Securities Exchange Act of 1934 impose legal liability on CPAs, and the liability under these statutory laws will be discussed in more detail later in the chapter. Other sources of liability for CPAs include criminal statutes and the Racketeer Influenced Corrupt Organizations, or RICO Act. The RICO Act will be discussed later in the chapter. Since the federal Securities Acts allow common class action lawsuits in which an entire class of investors becomes the plaintiff in a single legal action and hold CPAs auditing financial statements to very strict standards, Most lawsuits against auditors by stockholders or bondholders of publicly owned corporations allege violations of the federal statutes. CPAs accept the duty to exercise due professional care in discharging their duty to the client that they have entered into a contract with. The client is ordinarily the company itself as contrasted to the stockholders. But the contract obligations are important because they may provide the client and third parties additional recovery rights if there is a breach of contract. In order for a client to establish CPA liability, they must prove that the CPAs accepted a duty of due professional care, and there was a breach of that duty, and the client suffered losses, and the losses were caused by the CPA's negligent performance. The auditor's duty is defined by generally accepted auditing standards, the engagement letter, and legal considerations. In a breach of contract action, the client establishes that the CPA's duty was breached by showing that the auditors did not perform the obligations listed in the engagement letter, or that their performance did not meet professional standards. As we discussed in the previous chapter, the auditors must design their audits to obtain reasonable assurance of detecting misstatements due to errors and fraud that are material to the financial statements. In discharging their duty, the auditors must exercise due care and professional skepticism in planning, performing, and evaluating the results of audit procedures. It is important to note that the requirements for the audit do not imply that the auditors were negligent when misstatements due to errors or fraud are later found to exist in audited financial statements. A plaintiff's losses or damages are dependent upon the nature of the engagement performed by the CPA. In a financial statement audit, they may include losses by a client from embezzlement. On a tax engagement, they may include tax penalties or extra taxes paid. Causation exists when damage to another is directly attributable to a wrongdoer's act. Even though a public accounting firm might have been negligent in rendering services, it will not be liable for the plaintiff's loss if the negligence was not the proximate cause of the loss. Demonstrating the client's contributory negligence is one means of showing that the auditor's negligence was not the cause or sole cause of the client's loss. Many states rely on the concept of comparative negligence, which permits juries to examine the issue of causation and assess a proportionate amount of liability based on a percentage figure of fraud to the CPAs, any other defendants, and the client. Joint and several liability represents another approach to liability that in general benefits the plaintiff against multiple defendants. Under joint and several liability, the defendants are liable for their pro rata share of any damages, but they may have to also pay for damages of other defendants who prove unable to pay their share. Third parties bringing an action against a CPA must establish that their losses resulted from the CPA's performance and that the CPAs breached a duty of due professional care. In a typical case, a third party seeking damages from a public accounting firm seeks to establish that it sustained a loss caused by relying upon misleading financial statements, which included an audit report that was the product of an inadequate audit. A plaintiff who can establish gross negligence or fraud on the part of the auditors, as well as breach of duty and losses, will be able to establish liability against the auditors. In some jurisdictions, a plaintiff need only establish ordinary negligence to establish liability against the auditors. This slide is a summary of third-party common law liability for ordinary negligence to third parties and the requirements for a third party to recover losses due to the CPA's ordinary negligence. These approaches will be discussed in more detail in the next slides. The most widely cited common law precedent stems from the landmark case Ultramaris v. Touche & Company, 1931. In this case, the defendant CPAs issued an unqualified opinion on the balance sheet of a company engaged in the importation and sale of rubber. On the basis of the CPA's opinion, Ultramaris, a factor, made several loans to the company. Shortly thereafter, the company went bankrupt, and Ultramaris sued the CPA firm for ordinary negligence. The New York Court of Appeals ruled that the CPA should be held liable for ordinary negligence only to their client and any third-party beneficiary specifically identified as a user of the CPA's report. In Credit Alliance Corporation versus Arthur Andersen and Company, 1985, the court stated that before auditors may be held liable for ordinary negligence to a third party, they must have been aware that the financial statements were to be used for a particular purpose by a known party or parties and must have taken some action to indicate that knowledge. The principles of auditor liability for ordinary negligence to third parties is expanded by the American Law Institute's second restatement of the law of torts. In this approach to third-party liability, also referred to as the foreseen third-party approach, the auditor's liability for ordinary negligence is expanded to include third parties who are foreseen users of the audited financial statements. The specific identity of foreseen users need not be known to the CPAs. This approach was used in deciding Rouge Factors, Inc. versus Levin, 1968. The courts in many states followed this principle of liability to third parties. In Rosenblum versus Adler, 1983, the New Jersey Supreme Court rejected the approaches arising out of Ultramaris and the second restatement of torts and established a very different standard. The court findings in this case were that CPAs can be held liable for ordinary negligence to any third party that the auditors could reasonably foresee. While this approach has the potential to increase auditor liability, few states have elected to follow it. New Jersey subsequently overturned its findings and moved toward the Ultramaris approach. The three common law liability approaches and the parties that may recover for ordinary negligence are summarized in this slide. Under Ultramaris, only third-party beneficiaries that are known users may recover. Under the restatement of torts approach, third parties who are foreseen users may recover, and under Rosenblum, any foreseeable user may recover. Common law cases are decided in large part by reference to established precedent, that is, past decisions. The Ultramaris or known user, restatement, foreseen user, and Rosenblum, foreseeable user approaches create conflicting precedents as to which third parties can hold the auditors liable for ordinary negligence. Variants of each of these approaches exist in the various states. It is important to remember that any third party that suffers losses caused by reliance on the auditor's representations can hold them liable for proven gross negligence and fraud. Litigation against auditors that is based on statutory provisions does not enjoy the latitude available under common law. While common law can vary from state to state and can evolve with differing factual circumstances and changing conditions, statutorily based litigation is constrained to a great extent by the underlying law. This slide is a comparison of auditor civil liability under the 1933 Securities Act, Section 11, and the 1934 Securities Exchange Act, Sections 10 and 18, and in the next slides we will discuss these statutory liabilities in more detail. Civil liability under the Securities Act of 1933 comes from the registration statement that is required to be filed when securities are first offered for sale to the public. Included in the registration statement are audited financial statements and numerous other disclosures. Both the company and its auditors may be held liable to purchasers of the securities in the event that the registration statement is found to contain a material misstatement. Plaintiffs must only prove that they have sustained a loss and that the registration statement was misleading. They do not have to prove that they relied upon the registration statement or that the auditors were negligent. In defense, the auditors must prove that they conducted the audit with due diligence, that the plaintiff's losses were not caused by the misstated financial statements, that the plaintiffs knew of the financial misstatements when the securities were purchased, or that the statute of limitations has expired. The Barr-Chris decision above, although decided over 40 years ago, remains the standing precedent for auditor liability in these cases. The Securities Exchange Act of 1934 requires all companies under SEC jurisdiction to file annual audited and quarterly reviewed financial statements with the SEC. They create potential liability for the filing company and its auditors to anyone who buys or sells the company's securities in the event that these annual statements are found to be misleading. The 1934 Act offers protection to both original and subsequent purchasers and sellers of securities. Plaintiffs must prove they sustained losses, the financial statements were misleading, and that they relied upon the financial statements. The Supreme Court, in the case of Ernst & Ernst versus Hochfelder, ruled that plaintiffs must prove scienter on the part of auditors to recover under Rule 10b-5 of the Act. Scienter is an intent to deceive, manipulate, or defraud. Under Section 18 of the Act, auditors may avoid liability by proving good faith, which they will normally be able to do unless they have been guilty of gross negligence or fraud. Auditors can also rely on causation for both sections if the losses were caused by factors other than the auditor's behavior. Prior to the Private Securities Litigation Reform Act of 1995, defendants were jointly and severally liable for plaintiffs' losses under the 1934 Act. This Act changed this liability so that if one or more of the defendants are not able to pay their share of the losses, the auditors will have unlimited joint and several liability only to certain small investors. To other investors, the auditor's liability for losses caused by other parties is limited to an amount not to exceed 50% of the auditor's proportionate share of the losses. If the auditors were knowingly involved in the violation of the law, then the joint and several liability may be imposed. In 1970, Congress enacted the Racketeer Influenced and Corrupt Organizations Act, or RICO, as a weapon against mobsters and racketeers who were influencing legitimate business. The reason that we are discussing it is because racketeering activities were defined to include mail fraud and fraud in the sale of securities. It was used against CPAs prior to 1993, but after Reeves versus Ernst & Young, the Supreme Court ruled that accountants could not be held liable under the RICO Act unless they actually participated in the operation or management of the organization. Subsequently, the Private Securities Litigation Reform Act of 1995 eliminated securities fraud as an offense in a civil RICO action unless there is a prior conviction. Auditors can have criminal charges filed against them under the Securities Act and the RICO Act under certain circumstances. In the Continental Vending Machine Corporation case described above, the U.S. government brought both criminal and civil charges against the CPAs, and the CPAs were convicted, although later pardoned by the President. In the United States versus Arthur Andersen case, Andersen was accused of the wholesale destruction of documents relating to the Enron Corporation collapse. The Andersen representatives claimed that the destruction was carried out as part of its normal document retention policy. The prosecution emphasized the large volume of documents destroyed, but the verdict primarily was based on an email in which an attorney advised an Andersen partner to revise a memo to omit certain information regarding an Enron press release that Andersen felt was misleading. Andersen was convicted and later went out of business, but the conviction was overturned by the U.S. Supreme Court based on inappropriate jury instructions. The SEC has the power to suspend and disbar CPAs from reporting on SEC registrants' financial statements. On occasion, the SEC has taken punitive action against public accounting firms when it has found the audit work deficient with regards to financial statements filed with the Commission. In recent years, the SEC has taken action against public accounting firms by the use of consent decrees in which CPAs have agreed to certain penalties or restrictions. The Private Securities Litigation Reform Act of 1995 requires auditors to play more active disclosure roles with respect to their clients. Auditors who discover illegal acts by a client are required to report them to the board of directors of their clients, and in some cases, auditors are required to report those activities to the SEC. The PCAOB may also conduct investigations and disciplinary proceedings of both registered public accounting firms and professional employees. Board sanctions may include monetary damages, suspension of firms and accountants from working on engagements for publicly traded companies, and referral of criminal cases to the Justice Department. CPAs are subject to legal liability that when they perform accounting services such as write-up work and compilations of unaudited financial statements. Compilations of financial statements refers to the preparation of financial statements based upon information provided to the CPAs by the client. These are not intended to lend any assurance to any party that the CPAs have determined the information to be reliable. A review of financial statements consists of limited verification procedures, substantially less in scope than an audit, designed to provide users of the unaudited financial statements with a limited degree of assurance as to the statement's reliability. In the case of 1136 Tenants Corporation versus Rothenberg case, the court found that the auditors were liable because they had led their client to believe that they were performing an audit even though they stated that they were only performing write-up work. Also, the court stated that when the CPA firm found that there were missing invoices, they had a duty to follow up with this with the client. The 1136 Tenants Corporation case illustrates the need for CPAs who prepare unaudited financial statements to adhere closely to the AICPA Code of Professional Conduct rules on integrity and objectivity, use engagement letters, be alert for and follow up on unusual items, and report on financial statements using clear and concise standardized language as set forth in the Statements on Auditing Standards and Statements on Standards for Accounting and Review Services. In addition to the preceding court cases, numerous other actions against CPAs under both common law and the 1933 and 1934 Securities Acts are pending trial. As such, it appears that lawsuits will continue to plague the public accounting profession. What then should be the CPA's reaction to this age of litigation? First and foremost, the CPA must place emphasis on complying with generally accepted auditing standards and professional ethics. Recent court cases disclose numerous instances in which the auditors did not fully comply with one or more of the auditing or ethical standards. Retaining legal counsel that is familiar with CPA's legal liability and maintaining adequate professional insurance is essential, although liability insurance should never be considered a substitute for adherence to standards and ethics. CPAs need to thoroughly understand the client's business, as one of the major causes of audit failures has been a lack of understanding by the auditors of the client's business and industry practices. Use of engagement letters is a must for all professional services. These help to prevent misunderstandings with clients. Careful planning of audits to assess the risk of errors and frauds is a generally accepted auditing standard and should include identification and special handling of areas where there are material weaknesses in internal control. Exercising extreme care in audits of clients in financial difficulties or with a high degree of business risk is warranted. Creditors and shareholders of insolvent companies are likely to seek recovery of their losses. Last, working papers should be professional and completely assembled, as we will discuss in Chapter 5. And this is the end of the presentation for Chapter 4.